To the side of me, I have our village attorney, Mike Pasquinelli, our other village attorney, Mike Carroll, and our village manager, Joe Baber. We all know what tonight's meeting is about. We have the project limits for 143rd Street and the proposed expansion, what the Will County Board is doing. I'm going to turn the mic over to them just because I'm under the weather. They know more about this than I do. I'm going to start with Mike. There's two mics. I'm going to hand the mic over to Mike Pasquinelli.
Okay. Good evening, everybody. Just want to do a quick introduction here. My name is Michael Pasquinelli, and I'm an attorney with the law firm of Peterson, Johnson, and Murray, Chicago, LLC. Myself and my colleague, Mr. Michael Carroll, we are the employees of the law firm that are your village attorney. We're here today basically for purposes of an informational gathering so that the village can share with you all some of the defenses that we as a village are going to be asserting against the county who's trying to acquire not only your property, but trying to acquire the village property as well. A couple of ground rules though before we begin. We're about 45 or so people, and it's important when we have meetings and conversations and discussions like this that we all understand how this format's going to work, okay? Although Mr. Carroll and I work for the, well, strike that. Today's not a forum basically to discuss the substance of the ongoing lawsuit that's going right now between the Will County Commissioners and the County Executive. This is simply an informational meeting by the village so that you guys can get an understanding as to the various defenses that we, the village, are going to be putting up. And these may be defenses that you may want to follow in any defenses that you have with your private attorneys or private counsel down the road, okay? We are not, Mr. Carroll and I, although we're the village attorneys, we're not your attorney. We're the attorneys for the village. So what we're saying to you today cannot be construed as legal advice to you. Certainly you always see those disclaimers in all these presentations. We're not your lawyers. We're not creating an attorney-client relationship today. It's important to note here that this is not a village board meeting. We don't have an open comment portion for today where people are going to get up and ask questions and answer. That's just not how this forum is set up. This is informational from Michael and myself and also potentially the village manager to share with you what we're doing, what information that we're receiving. As you know, Ms. Casson over here has a sign-in sheet. This way the village can get an understanding as to where the county board is at in the process of potentially reaching out to you all for purposes of acquiring your property, okay? So it's important that we sign in if you haven't done so already. That way we as a village can get a good understanding as to where the county is at in the process. A couple of things too, we talked a little bit about the sign-in forms. We know, as you know, Michael and myself, we talk about this all the time, and I've sat at the board meetings. We know how upset you are, first and foremost. We've listened, we've seen it, we've all been present at those board meetings. All these trustees that are here, the ones that are here today, and I can share with you, the ones that I speak with all the time in executive session, all of them understand the pain and the anger that you all have with what's going on here. We are not, the village of Homer Glen is not the entity, local unit of government that's trying to get your land. We are the village that, like yourselves, we're part of this in the sense that we're a victim on this too. They're trying to get our land too. So the village owns some property along this corridor here. And let's talk a little bit about the expansion plan. So Will County Department of Transportation is planning on expanding 143rd Street from right around Lamont Road all the way to Bell Road. And as I said before, not only are your homes affected with this, but the village also has property that we currently, that's been dedicated to us, or that we're presently in process of obtaining that is potentially subject to eminent domain too. And we'll get into a little bit about what eminent domain is. But I want to...
just going to say, can you guys hear him in the back?
Oh, I'm sorry.
Would it be better to use this one?
Just hold that.
Oh,
Yeah, if you're moving around, just hold the mic.
that's okay.
It's closer to you.
Okay, is that better? Okay, so again, we're in this with you. We're not the ones that are trying to take your land. Like you, the village has land that they currently have title to or that they're in the process of possessing that the county is seeking to acquire as well, okay? If you guys thought for whatever reason that the format was going to be different, that it was going to be more like a town hall sort of a setting, certainly we apologize for that, but this is the structure that we have put in place today. There's various things that are in play here, namely the Meetings Act, and that's not what this is. This is not an open meeting. So if for whatever reason you don't like that format and there's better things that you all had planned to do, certainly Michael and myself aren't going to be offended. We understand. But if you want to sit here and listen to our brief presentation today, we ask you to follow these rules, okay? Before we get into the eminent domain process, the mayor had asked that I gave a quick synopsis as to what's going on right now in the lawsuit that the Will County Commissioners have against the Cook County Executive, Ms. Jennifer Bertino-Tarrant. Real quick, obviously the Village of Homer Glen is not a party to the lawsuit. The individuals that are parties to the lawsuit are all the commissioners, the Will County Commissioners. And those folks have filed a lawsuit in the 12th Judicial Circuit, Will County, Illinois, and it's docketed in case number 2024 CH 00084. In that complaint, what they're doing is they're seeking equitable relief. At law, we have two different things. We have what they call legal relief, where we're seeking money damages. And on the other side, we have equitable relief, where we're asking a court of equity to affirmatively do something, either stop somebody from doing something or force them to do something. So in the lawsuit that's been filed, the Will County Commissioners are asking that the court stop the Will County Department of Transportation for doing what they're doing, okay? As far as where it's at in the process, a review of the docket shows that a motion to dismiss has been filed. That motion to dismiss has not been heard yet. Intermittently on October 4th, there were a couple of motions that Michael and I were able to pull and read from the docket. One was a motion for leave to file a response to the motion to dismiss and stanter. That's pretty standard. What happens in a lawsuit where you have a plaintiff, in this case you have the commissioners that are seeking to enjoin and stop the Department of Transportation from doing what they're doing, the executive went ahead and filed a motion to dismiss that action. That's pretty standard. That's part of the playbook. And then the commissioners then go ahead and they file a response. So that response, there was a motion to file that response that was filed on October 4th. In addition, there was also a motion by the commissioners to appoint a special state's attorney. All of those motions are set for hearing on December 11th, 2024. Now, Michael and I looked in the docket. We didn't see any entries for the actual injunction hearing. Typically, the motion to dismiss, motions for special appointments, all those motions precede the actual substantive motion on the hearing to enjoin the executive's action. Okay, so all of these motions are predating the actual end motion, which would be seeking the injunctive relief. So there's been some discussion. People have been asking the village, hey, what's going on over here? Have you seen anything in the docket? When is this hearing happening? Nothing is happening until December 11th. And on December 11th, from what we see, the hearing is going to be limited to the appointment of the special state's attorney and potentially a hearing on the motion to dismiss. All right, so that's all we have as far as what's going on with that Cook County or that commissioner lawsuit, and that's pretty much all the information that we have to share with you on that. Okay, so moving on to why we're actually here. The slide that Michael showed us before with that 143rd Street expansion, everybody, all the board of trustees, everybody here and everybody else that isn't here today, everybody wants this stopped. Okay, so in order to stop the action by the Will County Department of Transportation, Will County has to first and foremost acquire the property. And the property that they're acquiring, Michael, we can pull that one up real quick. I'm sorry.
Make sure you're talking your mic.
No? I'm sorry, man.
You stay close.
How about I just do this one here? There you go. Okay, so the property that the Department of Transportation is seeking to acquire runs from Lamont Road to the north and all the way to Bellem Road. And they're seeking to acquire this property both on the north of 143rd Street and the south. Now, how much property are they seeking to get? Well, it all varies. From the plans that we've looked at, it varies in the north between 10 and 15 feet of actual property that they're seeking to acquire. And on the south, we see numbers anywhere between, on an estimate, and again, this varies between 20 and 25 feet. So they don't actually know. In addition to this, they also are seeking to acquire easement rights. So whenever you do big construction, when you're trying to expand roads and do those sorts of things, not only do you acquire the land that you need to put the road on, but you also have to acquire property to actually engage in construction to construct that road. So the Will County Department of Transportation should be in the process of reaching out to all the owners along 143rd Street, both north and south, to both acquire property, which again, between 20 and 25 feet, or 10 and 15 feet. Those are only estimates, they vary, and also those construction easements, okay? So that's the first step. So that kind of gets us to the next question. How can Will County Department of Transportation go about acquiring that property? Well, there's two ways they can do it. One, you can do it voluntarily, meaning that the government basically gets to the private landowner and says, hey, we want to buy your land, let's make a deal. That's what we call a voluntary acquisition by a governmental entity. The second is through a process called eminent domain. Let's get that eminent domain slide up, Mike. And that's kind of what we're here to talk about. There's been a lot of, I don't know, misinformation, misunderstanding. Eminent domain is a word of legal art. Eminent domain is a inherent power that a sovereign has. Now, historically, and we have this little bullet point here, we'll talk briefly about it. Historically, the power of eminent domain was vested in the sovereign. We lawyers, when we study in law school, this actually tracks back to ancient times, back as far back as ancient Greece, and all the way through medieval France, and so on and so forth in England, and to where our current foundation of our country is, both colonial and post our United States Constitution, and the establishment of our state governments. And what is it? It's the right that the sovereign has to possess your property. And again, this is a basic tenement of common law. You didn't give anything up. The sovereign, as the governing body, whether it be the Crown in England or whether it be the United States federal government, has the superior right of possession of property. They have a lien on everybody's property that they own. That lien is eminent domain. The right to, and the word of art that we use, is condemn. Condemn that property for a public use, provided they give you just compensation for it, okay? So nobody here did anything wrong. There hasn't been some crazy law that's been recently passed or something that people abdicated your rights. No. The right of the sovereign to acquire property by way of eminent domain has existed from the beginning of ancient civilizations to where we're at today, okay? So that kind of gets us to our next point. What limitations are placed on the government's power to actually acquire and possess our property? And that's where we have both the Illinois statutes and the Illinois Constitution comes into play. Let me talk a little bit about that. First, we have the Illinois Constitution. So, and again, I don't want to make this a history lesson, but it's important that everybody understands what's going on and how this process works. And the mayor and the trustees had asked us to share this info with you. So, Article 1, Section 15 of the Illinois Constitution, it doesn't grant the Illinois governing body the authority to condemn or to use eminent domain. They already have that right. That's an inherent right that any sovereign has, is the right to possess property, period, for public use. What Article 1, Section 15 does for us as the citizenry is it limits the sovereign's ability to do it. So what the Constitution says is that private property shall not be taken or damaged for public use without just compensation as provided by law. And they also establish that that compensation shall be an amount that's set by a jury. So when we read it, when us lawyers take a look at this, we have three protections here in the Illinois Constitution. One, it restricts the taking by the sovereign of property for a public use. So they have to demonstrate, first and foremost, the public use. Two, the sovereign has to pay you all, or the landowner, just compensation. And three, it requires just compensation to be set by a jury, who is a trial of peers. In addition to limitations and restrictions that we see in the Illinois Constitution, we also have limitations and restrictions that are imposed by statute. So Illinois, Section 111 of the Illinois Eminent Domain Act, and the site there, I don't want to bore anybody, but in case anybody wants to look it up, it's 735 ILCS 31-1-1. Basically, that is the Eminent Domain Procedure Act, and that provides limitations on how, the who, what, when, where, and why the Illinois governing body, through all of its various local units of government, can potentially acquire your property. Okay, so let's continue to, all right.
Mike, can I stop you here just one second?
Sure.
Just by show of hands, how many residents have been approached by the county to acquire their land already? I'm sorry, I'm trying to count it. 10? Has anybody actually signed off with the county? I mean, if you don't want to answer it, look at, all right, nice. Okay, and the reason why he's bringing this up, this is very important for you guys to understand the process of this, because like I had stated before in meetings, we do have a plan. We understand what's going on, and we're going to share that plan with you later. So all of that, what Mike is, I know it sounds boring because it bored me the first time I heard it, but it's really important to understand why he's explaining that. Sorry, Mike. Yeah, I'm sorry. I don't mean to call you boring, but.
No, it's just, we think it's important. We think it's important, and I don't want to bore anybody on constitutional law principles, that you all know that this is a right that the government has. Not this government, not the Village of Homer Glen. We're not the ones that are trying to take this property, but this is the right that's been established, well-founded, long before any of us have been around, okay? The provisions that are out there to protect us are Illinois law and the Illinois Constitution, in addition to some federal laws too, but we're not going to get into that today. The next steps in the process is, how, in what form would the county have to bring a suit against you in order to acquire your property? So what that's called is an actual complaint. And that complaint is required to, one, describe the property that they're trying to acquire. Two, they have to set forth their legal basis for acquiring the property, which is the public purpose and use that they intend on acquiring the property for. Three, they have to also demonstrate that the property that they're seeking to take is necessary in furtherance of that public use. So the government decides they want to take private property. They have to put together an actual legal complaint. That legal complaint has to set forth all of those 3 points. One, the public use, the necessity for it, and they have to demonstrate that they have the power and authority to exercise that right. A couple of things that the government has to do before they actually can file suit. And the law is very, very clear on this. The condemning authority, in this case, the Will County Department of Transportation, Will County, they have to negotiate with the property owner before bringing suit. That is clear as day, and that's the law. So when we're talking about the property that the village owns, the first and foremost defense that we are going to assert is, one, did Will County, before filing this lawsuit, did they negotiate with us, the Village of Homer Glen, in good faith before bringing the lawsuit? The case law is very, very clear on that, that they have to do so. So there's been folks that we've heard, through the village that, hey, well, they're going to take our property and so on and so forth. And one of the questions that Michael and I and that the board often try to grab their hands around is, well, have they reached out to these people yet? It's not something that they're being told, hey, it'd be a better idea if you do this. No, this is something that the law requires them to do, which is to reach out with you and to discuss with you and to negotiate with you in good faith to acquire that property. If they don't do so, then there's grounds to dismiss the actual entire action where they're seeking your property in a court of law, okay? So experience tells us that to establish this actual requirement, the county just can't throw a wild number at you. I mean, they actually have to negotiate in good faith, and to do so, that would be supported by an appraisal. Our experience tells us that, or a consultant's, a real estate consultant's opinion. So you can have a real estate professional can also provide that information. We've heard, Michael and I have heard some rumblings in some other corners that, well, we just don't want to do anything. Meaning that, well, maybe the village, if we get this notice, if the Village of Homer Glen receives this notice from the county, that they want to negotiate with us to purchase the property. We'll just pretend we didn't hear it, right? We'll just run away from it. That is not a good idea. 100% not the way to handle it. Reason being is this: the law is very, very clear that if the condemning authority, in this case Will County, if they've made good faith attempts to reach us in an attempt to negotiate a good faith offer and we don't respond back to them, they can use that as a defense that, hey, it's futile. These folks don't, we've tried to contact them, we went to their house, we've sent these letters, we've done A, B, and C, D, and E. Either they're abandoning their property or obviously they don't have any interest. And courts of law will take a look at that and they probably allow that to pass muster at that point, right? Because we as the individuals can't, or we as the village can't prevent the county from attempting to negotiate in good faith by burying our head in the sand. That does not work. That's not a strong defense. Rather, what we're going to be doing as a village is that once we receive those communications from them, we're going to reach out to them. Yeah, well, let's take a look at your appraisal. We don't have an appraisal. Well, we want to see your appraisal, okay? Those sorts of things can at least push the burden back upon the county or the condemning authority to give us the information that we need in order to negotiate in good faith. And if they go ahead and file the lawsuit anyway, that would be a potential defense that we have. One, that the county did not negotiate in good faith with us. It would have all the proof to show it. We asked to see a copy of an appraisal. They refused. We asked to see an assessment from their real estate professional. They refused. And we would make an argument for the court that that's not good faith. You know, that we don't know where these numbers came from. We as a village, we acquired an appraisal. We acquired a consultant that values this extremely higher than what they're valuing it at. They're not sharing this information with us. Therefore, they're negotiating in bad faith. And that could very, very likely be grounds to have the case dismissed, okay? So first and foremost, one of the strongest defenses that anybody has, certainly the village would have, is to make the argument that they're not negotiating in good faith. So they have to reach out to you, and they have to negotiate in good faith. The procedural way to make that challenge is you just don't go to court. You just can't say, hey, they're not negotiating with me in good faith, Judge. It doesn't work that way. You have to retain an attorney. We understand attorneys are costly. We get it. But the first step that any attorney that's specialized in this area or that has a familiarity with this area would do is what we say, filing a motion to dismiss. And in the eminent domain sphere, that's called a traverse motion. It's just a fancy term for a motion to dismiss. And in that motion to traverse, once it's filed, we're able to challenge four things. One, we can challenge the condemning authority's power to acquire it. Two, we can challenge the actual public use that's involved here. Three, we can challenge the necessity of the county in trying to acquire the property that they're seeking. And four, we challenge the fact that they didn't negotiate in good faith. And once you file that, once that's filed, that puts the brakes on the process, at least judicially, all right? As far as these first three things that we're talking about here, as far as the condemning authority's power to acquire it and the proposed use and so on, I don't want to tip our hand. I don't know if there's folks from Will County out there today that are listening to what we're saying. I don't want to share what the village's defenses are, but rest assured, one of the major ones, because this is black letter law, that if they fail to negotiate in good faith with us, that's going to be a super PAW. That stops the whole thing, okay? Once the eminent domain action actually is filed, the sovereign or the condemning authority can also engage itself in a process called quick take. This is something that we're all hearing all the time. We have people come up to board meetings and ask us, they ask Michael, they ask this board members, I'm sorry. They ask us all the time about this process, quick take, and what is it? Well, in order for the government to acquire your property, it has to go through judicial process. So they have to file a complaint. They have to serve the owners or folks with interest copies of those papers, and the court has to get jurisdiction over both the property and you. So that's step number one. Then we have that now it branches off, okay? If the condemning authority has been granted special authority through the state legislature of quick take, then they're able to file a motion to, quote unquote, acquire the title to your property quicker than what would normally happen through the judicial process, okay? So,
That happened in February.
I'm sorry?
That happened in February. In February at the Will County meeting, they approved to request the legislature to do a quick take. So that's the part that is concerning to me. I know we're not supposed to talk, but
Well, and I'll hit on that in a minute, okay? So, and that's a good point. And like we said, we lawyers, sometimes we get buried in the weeds and, the law school aspect of this, and I apologize for that. So I'm going to get it to the point. Mr. Carroll actually has handled this substantially right now for the firm, albeit in a different context. So I'm going to let Michael talk a little bit about that.
I am going to touch on a couple other things too that are important that Mike talked about. I just want to highlight again. He had mentioned earlier about some steps that the village is going to take, and I want to make sure that all of you are clear. Mike and I kind of take turns doing village board meetings, so you may have seen either or both of us at some of these meetings. We have intentionally been quiet about some of the things that the village had planned or was in the process of doing for the very reason that we did not want to tip our hand or let the county know what might be happening from our end because they weren't done yet. One of the biggest problems that we had in the very beginning, and we did discuss it a little bit in public, but we were very careful about what we said, was that initially our opinion, the state's attorney's opinion, everyone's opinion that mattered as far as the law, was that the village did not have standing to challenge this 143rd Street expansion. The village board and we have been taking steps since then to try and acquire standing, and Mike touched about it a little bit, and we have additional plans, and again, we're not going to get into detail about that, but we're finally at a point in time where we can talk about it enough to let you know that we can take steps to help you now. Before, we didn't have the standing to do so, so we had to remain quiet. So we wanted to explain that. A couple other things that Mike pointed out, I just want to also highlight. There are rumors flying all over the place about this process. One of the rumors we've heard is that the county offered some residents along 143rd Street 10 cents on the dollar for the property. That's not good faith negotiation. Another rumor we heard is that someone was offered just their mortgage payoff by the county, and that's not the market value of the house, so that's not good faith negotiation. So I presume those rumors are false, but even if they are true, it gets back to what Mike talked about. In order to file the lawsuit, they have to have negotiated with the property owner in good faith. And that's why the mayor asked, has anyone been contacted by the county? Has anyone been offered a dollar amount yet by the county? Raise your hand, please. Okay.
By mail, yeah.
Okay. So as Mike mentioned, make sure that you respond to that, because if you bury your head in the sand, you're going to have more problems in court. Among the things we're asking for when you fill out those cards or the sign-in sheet, if you have documents you're willing to share with us, we could take a look at it. We'd love to talk to you about it moving forward. But if you haven't signed anything where you've closed with the county, we would strongly recommend at the very least you contact an attorney who's experienced in eminent domain to discuss that. Well, back to the point that Mike asked me to talk about quick take. I am right now engaged on the other side of this, where we represent a different governmental unit in a different county that wants to take land through eminent domain by quick take. And so with the gentleman back there, I didn't see who it was, mentioned, there you are. Nice hat, by the way, I have the same one. But what he's mentioning is that the county, or the governmental authority that wants to take the land, first has to pass by a resolution or ordinance, a resolution or ordinance saying we want to go to Springfield and ask for a legislative quick take. So the county may have done that, but the other half of it, the more important half, is whether Springfield has said yea or nay to that. Now there are other exceptions. I don't want to get into it in great detail. One of them is more for like dilapidated areas. They're called enterprise zones. Anything that's an enterprise zone, like say one of the old, broken down malls that's now vacant. The legislature can create these enterprise zones around those areas, saying, okay, you don't need to come to Springfield to ask if you want to eminent domain this. We want you to fix it up. So we're going to call that an enterprise zone, and if it is an enterprise zone, you don't need our special permission to do a quick take. But the important part about quick take is, as Mike mentioned, you still have to file the eminent domain lawsuit first. You still have to meet those other requirements he talked about negotiating in good faith, having a public purpose. This particular parcel is necessary for that public purpose and a public use. Once you've met City Hall or whatever, and we need to get going on it because construction season is going to be grinding to a halt when winter hits or something like that. There's all kinds of steps they can take. But that hasn't happened yet here. So the quick take may have been authorized to be requested by the county board, but Springfield has not given that special authority yet. So we're still 2 major steps away from having a concern, and that's our major points on that. Mr. Bieber and I were talking before this meeting, your village manager, about making sure we let you know there's no scenario by which someone can come and say to start packing your stuff next week. Because there are multiple steps that have to be gone through before they could ever get to the point where the government can take your land. Because while the government does have that authority, like Mike said, going back to Greek times, they still have to follow the proper steps and they have to negotiate with you in good faith. I hope that answers your question, sir, and the fine hat back there.
Thank you, Michael. And, you know, just real quick, even if it goes through the quick take process, you can still file a traverse. So let's say that that package is before the Legislative Assembly, that they cross all the T's, dot the I's, and that bill gets approved. It doesn't mean that they're taking your house tomorrow. It doesn't work that way. What it means is they file the eminent domain action the same way that they do judicially. In the court of law, they have to serve you, they have to get jurisdiction over you, they have to get jurisdiction over your land, and then they have to bring you into court. And when you're in court, you can then challenge that quick take action. You can still challenge the right that the sovereign has to acquire your property. You're allowed in a quick take, even in a quick take motion, you're allowed to say, they did not negotiate with me in good faith. And that puts the brakes on the process. Whether you are doing it judicially, with or without quick take, makes no difference. The key, essential threshold, what we say in law, the sine qua non, but what absolutely has to happen is the government has to negotiate with you. So quick take doesn't divest you of that right. They have to negotiate with you in good faith, or they can't accomplish this through either means. Okay? The person back there that said they received an offer from the county, how long ago, did they tell you that you needed to respond to that within a certain period of time? Okay.
And they might have, and I think I just ignored it because I was so furious.
I understand, ma'am. Yeah, certainly.
I did the same thing though, but I got a letter in the mail from a law firm in Palos, and no different. I called and I'm a very polite person.
Sure.
Sarcasm there, Mike. But, I gave them my opinion, but they obviously didn't realize that I was renting that land and I didn't own it, so they didn't actually take the step of going further that I don't own that property, that I rented or something like that.
Understood.
Intelligent enough to even, but it was, I got a letter from a law firm in Palos I could provide to you.
Certainly. And I can share with you that and the Village Board of Trustees and Village President, the Mayor, and the Manager have shared that we can talk freely about this, so that's why I feel comfortable doing it now. Our playbook, and I can share with you briefly what our playbook's going to be. When we get that letter in the mail, the first thing I'm going to do is I'm going to send a response back to them in writing. You need to document what you're doing in these processes, everybody. If you just talk on the phone, that recording, we don't have a copy of that recording, no one's logging these calls, it's going to get lost, okay? Because, again, the government could basically just say, we've sent numerous letters to XYZ person, we sent numerous letters to the Village of Homer Glen, they never responded back to us. We've done everything we can do. It's futile for us to negotiate with these folks. It's over, okay? And the court could very much allow the eminent domain action, quick take or otherwise, to proceed. But if you, for me, how I'm handling with the village, and again, they've given me permission to talk about this. So we are going to respond in writing back, and I'm going to ask for a copy of the source documents that they're using to support their valuation. I disagree. I look at it. You're saying it's worth what, 10 cents? Well, I disagree with that. I would like to see a copy of your source documents, and let's see what they say. If they say no, well, then I'm going to get with our folks, and more likely than not, we're going to have our own appraiser and our own consultant send back another letter to them and advise them that their number is grossly undervalued. I'm not going to tip my hand and tell them what that number is. I'm going to tell them that they need to negotiate with me in good faith and demand that they do so. What this will do is it'll put the burden on them like it's supposed to for the government to negotiate with us in good faith, okay? And I keep saying government. We too are we are the home rule municipality that the Illinois legislature basically has entrusted the health, safety, and welfare predominantly here as a home rule village for everybody here, okay? We're not the ones, though, in this instance that are trying to acquire this property for a public use. It's the county. They've been given that authority to do so, obviously, through the roads that they have. One thing that we can share with you is that the village is interested. Mike, if we could put that first slide back up. The village of Homer Glen is very interested in potentially acquiring property along 143rd Street. So from here, from Lamont Road to Bell Road, the village, we've been in discussions, and we are interested in potentially acquiring slivers of land along that area, both north and south, for a public use. So if anybody has interest in potentially working with the village and acquiring some interest to those parcels, we would certainly like to hear from you. Okay.
1 second.
Yep.
Along that lines, we'll hint at what we're talking about, which is that we feel that there are greater defenses as a governmental unit, as a property owner, than a resident as a property owner, because a court, we believe, would be much more reluctant to grant eminent domain powers of one government over another. And so while the village already has interest or is obtaining interest to some parcels, some of the conversations we've had, and anytime you're acquiring real estate, those conversations are in closed session, because you don't want to, again, negotiate in bed or against yourself. If the public knew we were trying to buy a house on, Bell Road, and then someone knew that we were going to develop it, they're going to go and try and outbid us. So we don't discuss those things in open. But if you're interested, you have a property along 143rd Street, the village is willing to talk to you about that, because they wouldn't need your entire property. It might be something where they can get an interest in part of your frontage, and that might help with the whole defense of the eminent domain. So that's as far as we're willing to talk right now. Oh, here we go.
I see a lot of residents confused, and there's a reason that we're discussing this, because the option is Will County comes and puts a 5-lane highway in between your homes. What if we had a memorial walkway down the side of 143rd instead of a 5-lane highway? Do you see where we're going with that? We're trying to...
You're saying that if you purchase it, they can't do anything with it. But I'm looking at it, big right on the other side, saying you've got 2 schools and a fire department.
And we wouldn't have to, you know
already
what?
own it, don't you?
No, we don't. No, the school district does. But we don't need all of it. If we just have parcels where we have a nice walkway down there, it's just a walkway, right? It's not a highway, and you still keep majority of your land. It's just a play. It's just a way to overcome this highway. I still see a lot of residents confused, but without getting too much into detail about it, that's why we're saying that we're looking and we're interested in acquiring land, okay?
Yeah, and currently the village does have interest in property that's along 143rd Street. And which we it's been dedicated to us. But just the fact that the village owns property doesn't mean that it's going to stop this project, okay? What it means, though, hold on, what it means is we have a seat at the table. We can work and act as the tip of this spear to lead a charge to try to stop this thing. And the more property that we're able to acquire, the more interest that we're able to acquire, the better our voices will be heard. So again, anybody that has any interest that's along 143rd Street, I know that the village is interested in potentially acquiring those parcels or parcels, segments of that land. Certainly, please share that with the folks that are here today. Michael, anything?
No, that's pretty much covered. Want to go back to this?
Yeah.
I don't have anything more you want to hit on?
At Oliver, no. Here at school. Still some slides left.
Okay.
I'm okay with answering some questions.
Yeah.
I know we...
Oops, sorry.
I know we said we weren't going to open it up to like a question and answer sort of thing, but I know what they just said kind of left a lot of unanswered questions for some of you. So I'm willing to take a couple of questions if anybody has anything they want to say or share.
I kind of do.
Oh, okay. Chris Carnes, yes.
I keep going back to the fact that I have a fence on my farm to keep my animals in. And when they want to widen it, the deal is that they're going to remove the fence, do the project, and then put the fence in. So there's a safety insurance, my insurance company, I talked to them, and they were like, what? And I didn't want to tip the hand for them to raise my insurance price, but I know exactly what they're gonna do. So where does that come into the falls?
When you talk about eminent domain, we touched upon just compensation. Just compensation can take any number of things. For example, when the Village of Orland Park did eminent domain where Lang Lee's used to be, and Randy's Market, if you knew 143rd and LaGrange, they were required not only to pay for the land, they were required to relocate all the tenants to other locations. Orland Bakery went down LaGrange Road. Some businesses closed. Mr. Lee of Lang Lee, he passed away. His kids didn't want to run the restaurant anymore, but they were required to pay all those tenants moving expenses, get them into new leases, offered to relocate Davidson Cement. They offered to relocate them along I-80. So in your instance, they would have to mitigate the damage they caused to you. They would more than likely have to move your fence, replant it, compensate you for the land. All of that gets into that just compensation package. So this litigation gets very complicated. We do a lot of it from both sides, and that's why we say, I put it on the screen again, one of the ultimate takeaways, we don't want you to be afraid this can happen in the dark of the night, but as Mike mentioned, and I mentioned earlier, please don't ignore those letters. Please don't bury your head in the sand, because they can go to court at some point and say, well, we tried and they're not responding. Now, in your case, if you're a tenant, they didn't reach out to the right person, so they're not in good faith. Yeah.
I had a new fence put up and come to find out that the gentleman that originally lived in the home that I'm renting from had part of his fence on my neighbor's property. So I came home and had this huge gap, but I'm just wondering how much on the other side actually isn't mine that maybe would be willing to sell so you can have.
Well, and that's just it. It really comes down to, if you want to engage the village continuously with this project, make sure you fill out the sheet tonight so we know how to get a hold of you, because there may be, for future communication as we're working through these options. I did want to point one other thing out, I'm putting on the screen now, which is, as far as the legislative quick take piece, it's been stalled, as the last I heard. The state representative and the state senator that are involved on 143rd Street, I put up on the screen here. Senator Hastings does not list his email. You have to go on his website and fill out the contact me form. Where Representative Sheehan does, so I put his email up there for you, but I put both of their suburban phone numbers on there as well for you. So you might want to reach out to them, let them know that you're adamantly opposed to any quick take. I will say, why this is touchy too is, if the village did not own any land along 143rd Street, case law would be stacked against us. When I mentioned standing earlier, it's not just standing. There have been multiple instances in multiple counties throughout Illinois where a village, town, city tried to stop a county or the state from expanding a roadway, and they've lost almost every single time. So it really almost needs to be village land, where I think we're in a little bit higher position than Susie homeowner or Joey homeowner, because it's very tough just as a governmental unit to say, well, we're the village here and they're in our incorporated village and you're trying to expand. The state and the county win almost every time. So that's why this is kind of touchy. We've been monitoring it from the beginning, and that's why we've been kind of silent until now.
I know you had a question.
No, not really a question. Basically, what I'm concerned about is that becoming an expressway. Without 5 lanes, it's going to be 3 to 5 times the noise, the traffic, accidents.
Right, so I
and
can
repair.
touch base on that. That's what we're trying to stop.
Yeah.
And as we said earlier, we're all in this together. None of us want to this road. We don't want it expanded in any way. And the best way to help the village and the best way for the village to help you is to work together. The rumors, the misinformation, fake websites, all of that stuff needs to stop. And all of us take a breath and work together and contact the village. Contact village manager Joe Baber. He's got answers. We have a list of questions that are frequently asked. We are trying to overcome a project that was accomplished or completed in 2009. I'm trying to go back and undo things that were done for years and time-stamped and approved for so long. It's very hard for a village to try to overcome this task when you have people fighting against you at the same time. So there's times that we just got to put our blinders on and not listen to the rumors, not listen to the misinformation that's going on, and just put our feet to the ground and just keep working on it. And the best way for you guys to help us and us to help you is to work together. That's why they're saying we want to be the spearhead of this argument that we're about to take on. And I know people are asking, why didn't we join this lawsuit or that lawsuit? Because we have another angle. We don't want to all throw all of our ducks in one basket, or eggs in one basket, whatever. I've had a cold for 4 weeks. I'm surprised I'm even here. But do you guys understand what I'm saying? We're just trying to win a battle with you guys, for you guys. And like they said, we have our own property lined up on Golden Oak in 143rd. We have a big parcel there. And when we said we're trying to acquire more, it's not because, we're trying to be hungry like the county. We're trying to do it to save our road at the same time. So we're doing this for a benefit. Yeah. Well, no, we don't own the golf course property. It's right next to Old Oak.
And when we say we're trying to acquire small interests, we're not trying to acquire your entire parcel of land along 143rd Street, multitude of acres. No. What we're looking for is small amounts, what we call them slivers. A sliver, a sloth, or a sliver running from east to west, so to speak. Not a sliver, you know what I mean.
Is that a woolly mammal?
A sliver. The one critical point, though, to make in regards to the quick take legislative bill, it's imperative that in order to help put the brakes on this whole process, because quick take legislation allows the Will County to, once they file their complaints, they allow them to file a motion seeking quick vesting of title. That can happen. The playbook, how this typically works in this process is they file a lawsuit, they receive proof of service against you. Within 7 days, once they get proof of service against you, we're talking within 7 to 14 days, they notice up a motion, get you in court for purposes of filing this motion seeking to get title to your property. That's the power that quick take gives them. Now, it forces the individual person defending the case, in our case the village here, it forces us, Michael and myself, to quickly go to court, file the motion to traverse, bring up the points that, hey, if they have not negotiated with us in good faith, all those things to put the brakes on it. So for individual folks, it's essential that when these processes happen, that you get private counsel immediately, because time is of the essence, okay? So going back legislatively, that has not passed yet. So because that legislative process, that quick take right, can speed up the process for Will County, it behooves everybody here to contact your state reps and say, vote this thing down. Not only did the Will County commissioners approve, to get rid of the appropriation for this whole thing, which you could point out to your legislative representative, but certainly there's a whole public outcry here about this expansion. Homer Glen doesn't want it, you all don't want it, and that would be a good first step in stopping this process.
So to follow what Mike just said, the reason why we've asked you guys for your information is to notify you when we do something. It's a lot of steps to follow. My head spins sometimes when he tells me the next step we have to do. So it's best that we tell you, hey, this is what we're doing, which would lead you to do the same, follow the same. When we send our letters to the state reps, we should all be on it at the same time. Bombard them with that. We're all sending an email today, do the same thing. Hey, we're getting a bus trip, going down to Springfield, we should all be going. This is a team effort, and that's what I think what we're trying to say is, that's why we're trying to take charge with it, with this whole process. And I know Mike wanted to say something.
Yeah, along that line, just so you know how this happened, is the Board of Trustees voted to allow us to make this presentation to you, because while we can't represent you individually, we certainly can represent the village, and we do represent the village. We could also coordinate with you or your attorneys this process as we go through, which is why the mayor just told you what she said. So if you filled out the form and we can contact you, and we know that you're having the same fight that we are, you could have your attorneys call the village hall, and we can kind of coordinate what we're doing, or we'll already have sent you an email telling you what we're doing, so we can all work together on it. We didn't ask the one magic question. Has anyone received an eminent domain lawsuit yet from the county? Perfect. That's great. Joe? Yeah.
What is their argument for wanting this so bad?
Well, typically a roadway expansion is almost automatically a public purpose, a public use. So then they have to, the first slide we put up with the area they want to widen, if you look at their transportation plan, which they've approved, it says that they want to widen that roadway, and it would identify the parcels. And that's why Mike said earlier, we're estimating the amount they have to take, because it's not crystal clear on each parcel, 10 feet here, 12 feet here, or whatever. Their engineers would have to go in and finalize that before they file the eminent domain lawsuit on an individual parcel. But I think at that point in time, without having the fights we were talking about earlier, they can identify the area they want to expand, that it's for a highway or roadway expansion, public roadway, which is a public use and a public purpose, and that these particular parcels are necessary for that expansion. And the only remaining piece is that they negotiate in good faith. They have to do all those things before they can file that lawsuit. And if the lawsuit's filed and legislation hasn't happened in Springfield because they haven't passed it, or they denied it, or all of you fine folks contacting Senator Hastings and Representative Sheehan talk them off the ledge, then they would have to go through the slower process of eminent domain. But if no one's been served a lawsuit yet, we're a step ahead of the game.
And to answer your question just a little further, back in 2003, 2004, when they started this plan, they started to come up with ideas and thoughts, there was no representative from Homer Glen. It was from Orland Park and other areas representing our town. And they were under the presumption that 143rd Street was going to be a commercial corridor, and by 2030, we were going to be at 45,000 residents. And when that trend started, when this was completed in 2009, they were predicting that our trend of population was going to go up, but in fact, the population started to decrease, and we are actually, I think, 300 residents less than from when they originally done this plan. So we have different.
Isn't that something we would have? More in our favor?
Absolutely. So so when we were talking about the village taking slivers or offering, going back and forth. Sloths, yeah. We have other plans or other ideas too, and
That is a term, I'm sorry,
Yeah.
Madam Mayor. A sloth is a term. I was in construction before becoming a lawyer.
It's on a Brookfield Zoo.
the other thing is, when they put it in 159th Street, we're doing traffic studies. How many accidents happen on 159th Street? We're looking at that compared to 143rd Street. So we have different mechanisms of how to stop this. We just, unfortunately, the last time we let something out of the bag, it got used against us. And we have to protect you, all of you, and if we have to, get darts thrown at us every now and then because we're doing the best we can to protect you, that's okay. We'll do that.
Can I just say something real quick fast? I was approached by somebody to come over and dig like a 20-foot hole, and I don't know how big, it was super duper wide. It was like coming right up next to my barn because they had to do two utilities, excuse me. And I said, absolutely not. They said they wanted to rent the land even beyond where they were going to be building the road. So I said, no, because it was like, oh, they're going to give me like $5,000 for I don't know how many months of tearing up my front, area. Then I said no, and then it went down the way. So if we say no to that, where do they put these holes into utilities? Because I think the train place down the way.
I honestly don't think that's something that we or the attorneys can address at this time.
Okay.
I'm sorry.
Oh, keep that thing up by the way.
Sure.
You did get the number. And thirdly, so you're suggesting that we all have our own attorneys individually?
Well, you want to talk about that?
If you've received an offer, at the very least, like Mr. Pasquinelli said, you're going to want to ask them for their supporting documentation. It couldn't hurt to at least consult with an attorney. There's an economy and scale, so if you and several of your neighbors all went together and decided to, there are only, on the non-government side, there's only a handful of attorneys in the southwest suburbs that really know eminent domain, so you're not going to have far to look to find someone that knows what they're talking about. When we're on the government side, we do it all the time. Like I said, I'm doing a quick take for another municipality right now. We have a meeting Thursday night to discuss that. But if you were to get together with several people and hire one jointly, there's an economy of scale there. And if you have one attorney who knows what they're doing, representing 30 of you, for example, they're going to have a lot more weight behind their response than someone who's representing one or two. Just, it's the way it works. You see a solo practitioner representing one homeowner when there's 150 properties involved. The county's attorneys aren't going to be too worried about it. They know us and they know what we're capable of doing on litigation. And if you had an attorney that knew what they're doing as well, and 20 or 30 of you hired him or her, then I think you'd be a lot better off. So I would strongly recommend you at least consult with an attorney, get with your neighbors, maybe you can jointly work something out, but don't just ignore what they send you because that could be a problem.
Absolutely. You know, and just to add on what Michael said, I mean, that's just a great insurance policy for you. You know, even if it costs you, $1,000, $500, whatever it may be, you know, look at what do you pay your insurance premiums for? You know, for that risk of that cataclysmic event, and to be able to cover it in the event that something terrible happens. Getting good advice from a competent lawyer at this stage can really, really help you. Because if you ignore those letters that come your way, it could be used against you. I wanted to just add a couple of things to the lady that was asking about the public use and such. As Michael said, we do have defenses to public use and to necessity, but those are not things that we want to talk about or share today. What we can share is that one of the components that they have to prove is that they're exercising the right of eminent domain properly. And not only are we going to bring in the fact that they potentially did not negotiate in good faith with us, but we can also point to the ongoing lawsuit that's going on right now and the actions that were taken that tend to suggest that there was not the authority to do what it is that they're doing. So
Mike,
all those things in its totality.
can I ask you, is it safe to say if someone has been reached out to by the county for the purchase of their property, for them to at least contact our village manager, Joe Baber, let them know where they're at with that, so we have a heads up on?
Absolutely, Madam Mayor. I mean, we don't know where, obviously does it make sense for Will County to be trying to acquire village property first where Michael and I are the attorneys and would go right in and defend it? Of course not. That'd be silly. So they're more likely than not, they're going to be trying to acquire the property of other folks and other residents and go for ours last, right? Why would they want us leading the charge? It makes no sense to do it that way strategically. So we don't know as a village where you all are at in the process. So the reason for Ms. Caston here today and for our staff to get that questionnaire to you and to sign in is so that we have a good understanding as to where you individually are at in the process so we can assist with this.
You had a question, I'm sorry, we'll come to you too. Yes.
We actually consulted with one attorney for the eminent domain. He basically said, try to get as many people together as possible because for startup fee would be about $25,000. So, and then we spoke with another attorney who also said, try to get as many people together and do it politically. Is, you know, like again, like you said, coming together and doing the best you can to politically.
So neither one of those things is necessarily wrong. Obviously, the political piece I already put on the screen for a reason, because we all know elected officials listen to comments from their constituency, which is exactly why we're here, right? As far as the cost factor, I don't ever speak to other lawyers' fees. What I will tell you this, that if I were in private practice on the private side and someone came to me, you know this isn't going to settle. The county wants the property. It's going to go to trial. You're going to be fighting for a while. There are going to be motions. There are going to be multiple court appearances. So I will tell you that while I won't comment specifically about their fee quote, I can tell you that they probably, the fact that they quoted you what sounds high, probably means they know what they're talking about, because this is not something that's like a real estate closing where you can do it for $750. It's going to go to trial, and it's going to take a while. Whether it's quick take or not, because even if it's quick take, there's still all the valuation piece down the road. So it's not cheap, which is why Michael mentioned getting a bunch of people together. That's why I mentioned it as well, and that attorney told you the same thing. Because if you have 30 or 40 of you, now you're talking, you know, $750, $1,000 a piece. When you're talking about what you lose if you don't do it, it seems to be a good investment in my mind, but I can't speak for you on that. Ma'am?
The other question, we're on the 143rd and Park, so it's a concerted amount of people that we're talking about, but we're also talking about someone being approached for the construction easement, which is not the eminent domain.
Correct.
And is that something that you can help us with?
Not directly, no. Not directly, no, because again, we represent the village. We cannot, whoops. Uh-oh, it's dying on me here. What did I do? Oh, there we go. We represent the village, not the individual residents. So we represent you as a resident of the village, you know what I mean? But not individually. So construction easements, as Mike pointed out, are one of the things they're going to need. That's temporary There's usually a cash value associated with it, stuff. But no, that's,
But should we see something in writing for that?
absolutely. Yeah, it's a license like any other use of, if you're using your neighbor's driveway for a while, you could pay them a license fee, and it's almost always put in writing, yes.
Wait, the gentleman.
Okay, sir?
I'm just wondering if somebody reached out to the two school districts, I mean, they're government agencies, will they help out? Because Reed School is very close to Grove. Goodies Grove is a little further back, but I'm sure there is in their parking lot. So has anybody reached out to?
We're in the process of talking to them. I don't want to give too much information of what they stated, but yes.
Vermont would be represented completely different because of the affecting.
Right, so the other thing that we were talking about, they mentioned like a political thing, a political way of going about things too. I remember when Mayor Pekow came to the meeting, Mayor of Orland Park, he came to the meeting, the Will County, and it was me against him, and he had a laundry list of mayors that were for this expansion. What we need to do as residents is reach out to the other mayors who were not on that list and tell them, the mayor of Lamont, the mayor of Lockport, New Lenox, and so forth, and get them to join our side too. So if you guys have any affiliation with them, email them, talk to them too. They wouldn't want this through their town, but make sure you're not contacting the same mayors on that list though. So once we get that list, or we have it, well, we can give it to you as well. Yes, sir.
This is a quick question for the attorneys. Does eminent domain work the same for a temporary easement as it does for acquiring additional property?
No, the temporary easement could be like construction that goes on Bell Road in the county or the village, depending where it is, you know, might have to get.
The point is, if I say no, you can't have a temporary easement, then what?
I think they get it.
Yeah, and they can litigate it if there's a necessity, but it's not the same.
I'm sorry, can I jump on this one?
Yeah.
I can share with you that during the I-55 expansion, there was an attorney that had negotiated many of the construction easements along that corridor. And, you know, him and I joked the other day about the fact that it took so long to get I-55 rolling that he had to go back and renegotiate all these easements. So that being said, these are things that, those construction easements are key critical pieces to their puzzle. And they can't go about it by way of the eminent domain process directly, okay? So obviously, this is something that you have every right, just like how he was sharing with me, this is something that the individual owner said, no, we're not going to agree to it. We want to renegotiate this with you and require them to renegotiate all of those easements. All right, so that's very quick. What's wrong?
You stole our microphone.
Yeah. No. She's got a cold, but go ahead.
Well, the point is, they're
So yes, so to answer your question, that's a very, very key point, and that's something that you have the right to say no.
I think the question
just like the
is-
village would have the right to say no. If someone were to ask us right now, hey, we need a 20-foot easement for purposes of construction, what do you think we're going to say? Absolutely not.
Are
Why
you
should-
in Dawnwood, or, so that's a subdivision, so they're an association, so the association would then have to agree to the temporary easement,
Yes.
which I would advise against, because it holds up their process.
Right. I mean, it can be litigated, but it takes.
I mean, and Michael's right. I mean, there's no black and white, right, when we're talking about the practice of law. If the sovereign has the authority to go ahead and condemn your property, they certainly have the authority to go after and get an easement for it too, right? But it's going to take a longer time in that actual process. So why make their life any easier, is what I'm getting at.
Appreciate that.
Yeah.
And it doesn't foreclose the possibility. I've only seen this happen once. It's rare, but they could say, okay, we can't get an easement, then we're going to change the specifications of what we want to get eminent domain on and try and take that extra section as part of the necessity of the roadway. Generally, what they do is they would try and get an equitable remedy in court where they say to the judge, all right, we've got 99% of the frontage on this construction project acquired by voluntary easement, and we have one resident saying no, or in the case of the subdivision, it's a little bit different. But if it were a single homeowner, they could try and get a chancery remedy to force that easement for one parcel. But the nuclear option for them would be just to change their specs on the eminent domain and try and take all of it.
All right, I think we're going to wrap it up unless anyone has,
Thank you.
Yeah.
Just to encourage everybody to watch the village websites and things like that. We're watching that quick take bill down in Springfield. If that does progress, I'll encourage everybody to reach out to witness slips. There's a process for that, so just keep an eye on that. And provide us what your information, your emails, and that, and we can email you directly in the village. And also, if you need to contact anybody at the village, I'll be the main person. My email's on the website as well. Thank you.
Can I just ask?
Sure.
What are the ramifications for Bertino signing that and then vetoing?
That's what the lawsuit is right now. That's what the county board members are suing her for right now, which Mike will explain.
Yeah, offline, I would be happy to tell you my personal and professional opinion about that, but that's not why we're here tonight. Mike said that as part of the ground rules. We're not here to discuss the lawsuit, other than to tell you what's going on with it on the docket, which we already did. Want to talk to me afterwards, I'd be happy to tell you my opinion.
Oh, the information.
There you go.
Is that slide deck available someplace?
We'll put it on our website.
We'll put all the information on our website, because we also have Nicole Laha that's not on there as well. You can reach out to her and a few others that we're aware of that are on our site. Thank you, guys. Thank you all for coming. Thank you, Trustee Rose Reinders, Trustee Mason, and Trustee Steinlen for attending tonight. Oh, and Trustee Consolino, I didn't even say that.